Hello, this is the first lecture on sexual intimidation, Chapter 10. In this lecture, what we're going to take a look at is we're going to compare what we learned in Chapter 9 to what you're going to be learning in Chapter 10. So, in other words, we're going to compare the regulation of sexuality, pornography, and prostitution, which we just came out of, to looking at sexual intimidation, sexual assault, and sexual harassment. And then we're going to set the stage for thinking critically about sexual intimidation. And so we're going to talk about the differences between sexual assault and sexual harassment as categories. So let's get started. So in the last chapter, we examined regulation of sexuality with an emphasis on prostitution and pornography. This chapter looks at how sex and sexuality is used to threaten, control, terrorize, or coerce a person. So the last chapter looked at how expressions of sexuality, whether that's in terms of selling your sexuality for money, or portraying your sexuality in image or film, and also the way in which sexuality can be regulated in terms of marriage. This chapter really looks at not the displays of sexuality, but the way in which sex is used to harm others. And so in this chapter, you're going to be learning about rape and sexual assault. And we'll look at the chapter, will look specifically at how sexual assault law has changed over time. And we'll look at Title IX, which is the federal law having to do with discrimination in education, and how that led to focusing on sexual assault on colleges and university campuses. We're also going to be learning about sexual harassment as well, and differentiating in this lecture between what is the difference between sexual assault and sexual harassment. And while we're not going to talk about it in lecture, the textbook looks at another form of sexual intimidation, which is intimate partner violence. One of the big differences between regulating sexuality and sexual intimidation is the realm in which these public policy matters appear in. And so we can tell from the last chapter that when it comes to regulating sexuality, like prostitution and pornography, that this is regarded mostly as a public problem. That people are bringing their sexuality into the public domain, whether that is the marketplace for selling sex or the public domain of ideas and speech. But that regulating sexuality is a concern with the way that bringing sexuality into the public sphere can do harm, okay? And so, prostitution has been seen as harmful to society, harmful to the public, right? We talked about that last chapter, that prostitution is harmful to the public. Why? Because it can spread disease. Prostitution is harmful to the public because with prostitution comes other sorts of crimes, vagrancy, drug use around brothels. Bringing pornography out into the public sphere can degrade people's morals, right? It can degrade sort of like, our public sense of what is good and not good. And so regulating sexuality is seen as a very legitimate government exercise of government power because the government is there to make sure that the public is safe, right? And if things are happening in the public, well, then the government's got to step in and do something about it. And we saw from very early on that public policy, starting in the mid part of the 19th century, we see very early on that the government stepped in to regulate sexuality. It seems like sexual intimidation would obviously be a harm to the public realm. But surprisingly, that for most of U.S. history, sexual intimidation was regarded mostly as a private issue. And we'll be learning about why that is in the next lecture. But for the most part, that the government didn't seem like it needed to get involved when people were being intimidated sexually. And part of that was because when women were intimidated sexually by their husbands, it wasn't seen as a proper place for the government to interfere, because under coverture, women were considered property of their husbands. They could do with their wives what they wanted. So again, it's a private matter. And as we're also going to see in the next lecture, that it was only in the most extreme types of sexual assault that the government got involved. And that was when it came to rape. But all other sorts of non-consensual sexual conduct were seen as sort of the proper realm of government, right? So surprisingly, for most of US history, sexual intimidation, sexual harassment and sexual assault don't really get public attention. That it's best handled privately, and government should only get involved in the most extreme instances. And we'll see that those extreme instances are rape. And the fact that government got involved with rape had to do more with sexual norms, traditions, and stereotypes than it had to do with protecting women from harm. This changes dramatically in the 1960s, in large part due to feminist activism. And so, as we're going to see in the next lecture, feminists starting in the 1960s with second wave feminists raised a lot of consciousness and brought to the public agenda concerns about rape and sexual assault. And it's because of those actions and activities that sexual assault is taken out of the private realm and placed squarely in the public realm. Another difference between regulating sexuality and sexual intimidation has to do with the different approaches that feminism has taken to these two issues. As we saw in the last chapter, that the regulation of sexuality is about sexuality for the most part. And so it's about what women and men should do with their sexuality. Should they be allowed to sell their sex? If so, what implication does it have for sexism and for power dynamics between men and women? Same with pornography. That what impact does pornography have on women's status within a society? And so we saw there were really huge disagreements within feminists about whether or not prostitution and pornography reinforce sexism in a society, or whether or not women should be empowered and that they are free to make their own choices, and that they can use pornography to actually paint a pro-feminist, a pro-sex, positive sex approach to understanding sexuality. And so, we saw the big difference between radicals and feminists and liberal feminists, and how those caused huge rifts within feminism, divisions that remain alive and well today. So when it comes to sexual intimidation, feminists agree that sexual intimidation is not about sexuality. It's not about how we portray our sexuality and should we portray it in that way. But that sexual intimidation is really not even about sex and sexuality, but rather it's about power. And it's the way that sex is used to dominate others. And within feminism itself, there's really no fundamental disagreement about how the state should approach sexual intimidation. In fact, feminists are on the forefront, at least in modern times, since the 1960s onward, at placing sexual intimidation on the public agenda, seeing it as something very harmful, and seeing it as something absolutely necessary for the state to address and to prohibit and control. And so, there's no disagreement. Some feminists aren't like, yes, sexual assault, it ain't that big of a deal. Others are like, oh no, it's a huge deal. No. All feminists regard sexual intimidation as an incredibly important issue, and that there is agreement about the approach that the state should take on that. Your textbook will talk about that there are, while all feminists agree that the state should address sexual intimidation, there are differences in terms of how sexual intimidation should be addressed. And so that make sure you read in your textbook about equality feminists versus dominance feminists. Equality feminists, they are worried about always seeing women as the victim and not able to take care of themselves, and that the state needs to step in and constantly be looking after women and making sure that they are being protected from these dangerous relationships or these harassing work environments. And so there is a little bit of a difference in that equality feminists are like, don't treat women as victims first. Women can stand up for themselves. Dominance feminists really say that women need help, that that many institutions like marriage, school, and work are predicated upon sexist arrangements, and therefore they're sort of designed or tailored to abuse and intimidate and harass women. And they really, sort of like take that approach to how and the assumptions about how sexual intimidation should be approached by the state. Not big differences, but your textbook does talk about at least where we do find differences within feminism. It's between equality and dominance feminism, but it's a much smaller difference than the kinds of differences we saw with regulating of sexuality. Okay, the last thing that we're going to talk about here is the difference between sexual assault and sexual harassment when it comes to the law in the United States. So we'll start with sexual assault. So sexual assault is a crime, okay? That if you engage in any sort of, today, if you engage in any sort of non-consensual sexual activity, that's regarded as an assault, sort of like if somebody punched you, right? Non-consensual consensual sexual activity is a crime. It is codified in criminal law, both at the state and at the federal level. And as I said, it really revolves around non-consensual sexual conduct. It's important to realize or recognize that sexual assault is a crime because criminal law is really more serious law for a variety of reasons than civil law. And as we'll see in a moment, sexual harassment is not criminal law. Sexual harassment falls in the category of civil law, okay? And so sexual assault as criminal law means that it is that the state, whether it's the state of Wisconsin or any other state or the United States government, they have laws in the book that define what is sexual assault. And so what kind of activities constitute a crime. And if you engage in those activities, then you've committed a crime. And so when it comes to sexual assault, it's like any other crime. The state has the obligation to defend its laws. And so if they think that an individual has violated that state criminal code having to do with sexual assault, the state has an obligation to charge that person with a crime. Okay? Again, a very serious offense. Another aspect of criminal law is that, and the burden is put on the state. The state must prove beyond a reasonable doubt that this individual has committed this crime. And so when it comes to sexual assault, you will go. There will be a trial. There could be a jury, and then the jury or the judge determines whether or not this person is guilty as charged or whether they're not guilty, and then they're acquitted of that crime. And then furthermore, and as I mentioned, it's a high standard beyond a reasonable doubt, the evidentiary standard, because the consequences of being found guilty are profound. And they're profound because of the penalties that you can get. And so if you are found guilty of committing a sexual assault, the punishment could range from anywhere from probation to, depending on how violent the sexual assault was, could be a long-term incarceration. I'd have to look at the sentencing standards in Wisconsin, but it could be life imprisonment, right? And so it's a criminal penalty. It's very serious, and it's treated as such in our criminal justice system, at least since the 1960s. And we'll see how we came about towards that in the next lecture. Now, sexual harassment is not considered a criminal offense, but it is considered a civil offense. But just because it's considered a civil offense doesn't mean that it is not serious and that it's not illegal. If somebody engages in sexual harassment, they are violating the law, and violating the law is illegal. It is unlawful, and there are federal and state civil laws that prohibit sexual harassment. And so we have laws regarding employment laws, and within our federal employment laws, those federal employment laws prohibit sexual harassment. So if a company or somebody who works at a company engages in sexual harassment at a workplace, they are bound by sexual harassment federal law, and they could be sued for violating those laws. Same with if an educational institution is governed by Title IX, and Title IX, outlines sexual harassment on college campuses. And so again, that engaging in those behaviors is illegal, even though it would be a civil offense and not a criminal offense. So an individual who engages in sexual harassment has engaged in an illegal offense, but they are not charged with a crime. However, what they would be is they would be sued for violating civil law. And so if you're in a workplace and one of your work colleagues is sexually harassing you, you would take that complaint to human resources, and then human resources would be under law responsible for investigating that sexual harassment complaint and doing something about it. If that workplace doesn't do anything about it, then you can sue your workplace for violating civil law. Likewise, you could, sue your university if there was a sexually harassing professor, heaven forbid, or another worker at the university who is engaging in sexual harassment, and you'd bring that attention to the attentions of the office on your campus that deals with sexual harassment. You would make a report, and then the university would be responsible for doing something about it. And if they don't do anything about it, then you could sue them for violating civil law. Okay. So, when it comes to sexual harassment, an individual could sue another individual for harassing behavior, but usually it's an individual that sues an institution, okay? Because the institution is really the one that's responsible for following civil law, federal or state civil law that deals with sexual harassment. Now, if what we said that when it comes to sexual assault, that the state would charge an individual with a crime, and then there would be a trial, either in front of a judge or a jury, and then the individual would be, if they're convicted, they would be found guilty, and then they could get a criminal penalty, such as incarceration. There are trials in violations of civil law, but you're not found guilty, but you're found to be the responsible party. That your institution is in fact responsible for violating employment law or law that prohibits sexual harassment. The penalty that institution would get, or that individual would get, would not be a criminal penalty. The institution wouldn't be sent to jail. However, they would be asked to pay for the damages that their lack of action. So if you don't respond to a sexual harasser and you don't do anything about it, well, then the institution is responsible for paying the damages associated with that sexual harassment, and usually in a monetary sort of capacity. The evidentiary standard for civil offenses is it's high, but it's not as high as beyond a reasonable doubt. So when a jury or a judge is looking at the evidence before them and trying to figure out who the responsible party is, they look at the preponderance of the evidence. And if the preponderance of the evidence indicates that, yes, indeed, this institution is responsible, then that institution would be responsible for paying the damages that were incurred. Now, do keep in mind that harassment can be coupled with a criminal offense, like sexual assault. So for example, if your boss is requesting verbal requests for sexual favors, but then that's coupled with them sexually assaulting you in the mailroom, right? Coming up and kissing you in a non-consensual way, or touching you in a non-consensual way, or something even beyond that. That individual could be sued, or that institution could be sued for sexual harassment. But that individual could be charged with a crime as well because they've engaged in sexual assault. So harassment can be coupled with a criminal offense. Recording? All right, on the next lecture, we're going to chronicle the shift in status of sexual assault from a mostly private matter to a more fully public matter. And so we'll look at how sexual assault went from the public or the government only getting involved in the most egregious types of sexual assault, rape, to where today there are many more degrees of sexual assault that are fully incorporated into our criminal justice system.